The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your mostly bi-weekly podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined this week by IJ attorney Robert Everett Johnson, as well as Sheldon Gilbert, the director of IJ's Center for Judicial Engagement. This week, we'll discuss the mark of the beast on campus, defamation on campus, and due process on campus. Sheldon, kick us off.
Sheldon Gilman and Gene Lifter are employees of Cleveland Marshall College of Law. And after the 2008 financial crisis, and you'll hear a lot of tiny violins about this, the market really fell out from the legal industry. So lawyers across the country were getting laid off in droves. And as a consequence, fewer and fewer people were attending law school. It didn't make financial sense to attend law school. So you have law schools like Cleveland Marshall who are trying to figure out a way to make budget meet. And one of the ways that the school decided to solve the problem of low class rankings in terms of the law school rankings and how to deal with some of the other issues arising out of the financial crisis was a decision to cut the size of the law school admissions class. What that means is that you have less money coming into the school to do things like pay the law professors. Well, as you can imagine, a lot of the law professors and other employees weren't very happy about this, including two individuals that we just mentioned, Sheldon Gilman and Gene Lifter. And Gelman in particular, who's a tenured professor, spearheaded a union organizing campaign and said, hey, law faculty, let's get together, let's collectively bargain and try and see if we can increase or maintain our salaries despite the changes that the school is trying to make. And it looks like it was a pretty acrimonious fight between the dean of the law school, who was pushing this effort, and Sheldon Gilman, who was trying to unionize the faculty. At one point, there was a meeting over some of these faculty issues, and the dean of the school, really went after Gilman and said, shame on you, Sheldon, shame on you for some of the tactics you've been engaged in as part of this unionizing, right? So ultimately, the law faculty are able to successfully unionize. They enter into a collective bargaining agreement, and about a year later, Sheldon Gilman and Gene Lifter get their raises, their merit raises. And their merit raises were for a whopping $666. And that is the source of today's lawsuit.
So 666, also known as the mark of the beast, forms the foundation for this lawsuit. What are the claims here, Rob?
Well, this case is brought in federal court under 1983, which is basically a civil rights action. And the claim is that the university has engaged in First Amendment retaliation, that they have retaliated against Gelman and his wife for Gelman's protected First Amendment activity of union organizing, that this pay raise was both low and also symbolic. It's an interesting claim, to say the least. The sort of interesting footnote to this is that Gelman actually filed a complaint with his union, the same union that he had agitated to form, saying that this was retaliation for his union organizing. And the union told him, get lost. We actually don't think that this has anything to do with your union organizing activities. So dissatisfied with the union outcome, he then files suit in federal court saying that his constitutional rights have been violated. The trial court says no. They look at the record and they find that there's not enough facts here to find even a colorable violation of the First Amendment, and so they kick the case out of court. Goes up on appeal on the Sixth Circuit appeals. Long story short, really there's a lot of evidence here that while 666 might jump out at you as somehow symbolic, it actually was just arrived at by a kind of mathematical formula where there was a certain amount of money to be handed out in bonuses. It was divided equally among a certain group of professors who had a certain amount of a certain merit score, and the result of dividing it up was that everybody got $666. Some of the people who got that amount had engaged in union activities. Some of them hadn't. So there really wasn't any kind of inference to be drawn.
Yeah, the only other piece to this is the claims were brought by Sheldon Gilman, who says you retaliated against me for my union organizing speech by, only giving me a $666 raise, but also by his wife, who was terminated by the school. And she said, I was terminated because of my husband's protected speech. And the court said, well, hold on. In order to make out a retaliation claim, first of all, you have to be engaging in some sort of protected activity. And what you're doing is trying to piggyback on your husband's protected speech. And for that reason, we don't think you have standing. We don't think you have the right to be in the court and raising your claim. And so the court dismissed her claim as well. It's not inconceivable that if a husband and a wife are employed together and one of them engages in some sort of activity, that there could be a retaliation claim by the other. But in this particular case, she just really didn't provide any evidence that she'd been engaging in protected activity.
Yeah, and that part of the opinion was, I think, the strangest part of the opinion, because they easily could have dismissed her claim on the same ground that they dismissed all the other claims, which is there's just really no evidentiary foundation. But instead, they really went out of their way to reach this on jurisdictional grounds. And there's something very peculiar about that, because obviously a husband and wife are, they have an associational right that comes into play here. And an easy way to retaliate against, one person for their activity is to go after their spouse, because obviously that's going to come right back around, right? Like firing the wife has a huge impact on the husband. It affects his household income. And there's all kinds of cases that recognize that you can retaliate against one person by going after their spouse. So it's not really clear to me why the Sixth Circuit went that direction, and it has troubling implications, right? Like, the facts in this case are not very strong. There's not really a lot of evidence that there was retaliation going on. But in a case where you do have that kind of strong evidence, this could be a problematic precedent and could let the government get away with some pretty bad funny business.
Yeah, and none of the parties, the law school didn't brief the standing issue. The plaintiffs didn't brief the standing issue. So the court really reached out and said, this is the way we're going to handle this. It seems to me that, independent of the standing issue, again, there are basically three things you have to prove to make out a retaliation claim. Sheldon Gelman could prove the first two of those, but couldn't prove the third, which is that that the cause of the adverse action against him, the $666 raise, was in order to punish him for his speech, right? Now, with respect to Jean Lifter, really she just couldn't make out that first piece, right? And it's unclear why they kind of grafted on their analysis saying you weren't engaged in protected activity, protected speech. That's kind of the first thing you have to prove. Why they grafted that analysis onto a standing decision rather than just saying you didn't make out a claim.
Okay, let's move on to the next case, which comes out of the Second Circuit. Rob?
Okay, well, this is a case growing out of the infamous Rolling Stone article, and I think probably half the people listening know exactly what I'm talking about. This was an article that was published by Rolling Stone detailing the alleged rape of a woman on campus at the University of Virginia. Her name is Jackie. And the story that was told in the article in vivid detail was that Jackie was gang raped by a group of students at a fraternity. And this article sort of burst onto the national scene. It was read by over 2.7 million people on the internet alone. And then sort of it began piece by piece to unravel, as it turned out that there were various inconsistencies and things that were said in the article that couldn't be true. And all of this culminated with the actual withdrawal of the article by Rolling Stone, and the Rolling Stone issued an apology saying that they realized that the article was not backed up by fact. And this was something that sort of played out on the national frame. Now, since that time, there have been a number of defamation actions that have been filed, including one by an administrator at the University of Virginia that ended up with a $2 million verdict against the magazine and against the reporter who wrote it personally. And then this is another follow-up defamation action, and it's not brought by the administrator, who was actually named personally in the article. Instead, it's brought by students at the University of Virginia, members of this fraternity, who were saying that they were defamed. And the interesting question that is posed by this case is, can a person who is not named personally in an article nonetheless bring a defamation action claiming that they were defamed by the article? Because this article doesn't name any of the students other than one of the students who allegedly perpetrated the rape that is named by first name. But none of these students actually have that first name. So none of these students are named personally. Instead, their claim is, well, based on the facts that are alleged in the article, people thought that we were the ones, that there were people who kind of tried to connect the dots and say, well, based on where your room is in the fraternity house and based on the fact that you work at a pool.
Parents, family, friends, acquaintances, colleagues.
Right. Yeah.
A lot of people.
Yeah, I know. And you can see how this would be something that would be very difficult to live through, right? Like this article is being read by millions of people all across the country, and all of your friends, your family members are trying to figure out, who was it? And they're saying, gosh, you have the room on the second floor of the fraternity, and this rape allegedly occurred on the second floor, so, you must be the one. That's pretty awful. That's pretty scary. It's a hard thing to go through. And so they bring this lawsuit. On the other hand, they're not named in the article, so the Rolling Stone has so the suit, it's worth mentioning, is brought against both Rolling Stone and the reporter. And they have a not insignificant defense that, look, we didn't name you in this article, so how can you say that you were defamed?
Sheldon, how does the Second Circuit reason through this?
Well, it's interesting. The plaintiffs actually kind of allege that there are two different ways in which they could possibly have been harmed, even though they weren't named. And the first, as Rob suggested, is this idea that we could kind of suss out the identity of particular individuals, and that they would be known to family, to friends. Other reporters or bloggers were trying to figure out who they were, guessing who these individuals might have been who were participated in this alleged gang rape. But the other theory is a little bit different, which is what the court refers to as small group defamation theory, which basically says, look, even if you couldn't identify them individually, you have identified a very small group, this fraternity, and the membership of that group is small, concrete, clearly defined, and easy to figure out. And so even if you didn't explicitly say their names, you did explicitly identify the fraternity, and it's well known that they're associated with and members of the fraternity. So there's kind of two different ways that they're going at this. Now, what the Second Circuit is saying is trying to answer this question: how much information do you need to put in a complaint, in this case, a lawsuit claiming that you've been defamed, in order to get past just this first stage called a motion to dismiss and move forward with the lawsuit? Right. So that's actually the stage that we're at. Now, the district court said, I don't think you've put enough information in your complaint. For the most part, there are lots of different plaintiffs, and there's a lot of moving parts about, who has what piece of information. But in both of those theories, the district court basically said, I don't think you've quite put enough information together in your complaint to be able to move forward and proceed with things like discovery and all the other stuff that you do in the course of a lawsuit. And the Second Circuit says, no, we think you provided enough, right? There's enough in your lawsuit to be able to make out a plausible allegation that Rolling Stone, as the editor and the reporter, engaged in defamation. And so the Second Circuit says the lawsuit can proceed. For the most part, there's some wrinkles here with respect to some of the plaintiffs, but the lawsuit can proceed on both of those theories.
Yeah, and this ends up turning on somewhat, you might say, arcane details about these individuals, right? Like, so one of the individuals, one of the students, works at a pool, and the people who are discussed in the article, one of them is a lifeguard at a pool. Another one, lives on the second floor of the fraternity house, and that ends up being a key detail. So, like, those sorts of very specific details are enough. There's a third plaintiff who says, I could be identified as one of the people in the article because I ride my bike on campus. And there's mentioned in the article that someone rides his bike on campus. And the Second Circuit says, look, we don't think riding your bike is enough of an identifiable fact for you to proceed. But even that person is able to proceed on what they call the small group theory, that, look, basically anybody who is a member of this fraternity can sue saying, that's a small enough group that you have defamed me as a member of the group.
There's kind of an interesting question lurking in the background, which is, at what point does a group become so large that defamation like this really doesn't make sense, right? That, if like take the Federalist Society, which is the discussion of a lot of recent judicial confirmation hearings, it's not a small group. It's a fairly large group. And it's not kind of self-contained in the same way as this particular college fraternity. And so I think the court is kind of carefully guarding against opening the door to a lot of defamation lawsuits, where an organization is talked about in a particularly nefarious or malicious way, and you could possibly figure out all the members of that organization, but you don't want these massive sprawling lawsuits by every member of an organization saying, hey, you talked bad about my organization, right? So they're kind of guarding against that, but still opening the door to this interesting small group defamation theory.
Yeah, it is interesting. I think the decision is limited. On the other hand, there is something somewhat troubling about this, from a First Amendment perspective. I mean, this is an article that, it should never have been published. I think it's fair to say that. And it has in fact destroyed the career of the reporter who wrote the article. But the consequences that could come from this lawsuit are far broader than that. If you read the trade press, Rolling Stone is in an attempt to sell itself. And the existence of this lawsuit is enough that Rolling Stone is potentially may not be able to go through with that kind of a deal because a lawsuit like this poses the risk of an enormous amount of liability for the publication. Look at Gawker. This is a publication that was sued not for defamation, but for invasion of privacy, and got an enormous judgment. And the result of that, sued by Hulk Hogan, and the result of that was that the publication actually is now defunct. And it had, other sister publications that had been sold off to another media organization. So this kind of suit can actually not just affect the career of the reporter, which is perhaps appropriate, but it can actually sink an entire publication. Rolling Stone is a magazine that's been around a long time. Should something like this be, should the legal system be set up in such a way that an institution like Rolling Stone can be sunk by one mistake?
Yeah, I think that one of the pieces to the Gawker lawsuit that any media outlet is thinking about right now is how that lawsuit was funded, right? So there's an individual, a very wealthy individual named Peter Thiel, who really kind of had it in for Gawker for a long time for some of the reporting that they did on him. And he secretly funded Hulk Hogan's lawsuit against Gawker over Gawker's release of a Hulk Hogan sex tape. And then once you had this massive judgment against Gawker in favor of Hulk Hogan, kind of stepped out of the shadows and said, hey, I finally got my revenge. My goal in funding this lawsuit was to make you pay. And there's a little bit of a concern that, or maybe a lot of concern on the part of media outlets about this type of vengeance-based activist litigation that's well-heeled, well-funded, and, as powerful as media institutions are, maybe are not set up to defend themselves in litigation, with stakes like this. And that, I think, is part of what's driving a lot of the interest in the particularities of this case. I
think lurking in the background of this case also is something that's not discussed at all, but, in the First Amendment context where you're talking about a public figure, the Supreme Court has said that to prove defamation, you have to show actual malice on the part of the publisher. And, given what we know about how this article came to be, it seems unlikely that you could prove actual malice on the part of Rolling Stone or the reporter in this case. Instead, it seems like they were just overly credulous in believing the story that was told to them by this victim, that they honestly believed what they were publishing was true. So how is this lawsuit able to proceed? And it's not clear from the face of the opinion. My speculation would be that the court is essentially assuming that actual malice doesn't apply here because these aren't public figures. But it's an interesting question if you're suing not the individuals, or if the plaintiffs are suing not as individuals but as a group of a fraternity. A fraternity does seem to have a certain publicness to it that, Joe Schmo, the college student, doesn't have. And it seems to me if you're suing as the fraternity, you may well should be required to show actual malice on the part of the publication.
Going to the fundamental question of why the reporter and Rolling Stone were so credulous of Jackie, the alleged victim's claims, I think really raises some important questions, right? How do we deal with any sort of claim of of a crime by an accuser, and what are the next steps when we receive an allegation like that.
Okay, let's move on to the next case, which also comes out of the Sixth Circuit.
And this really gets to the heart of that question: what we do with the claims of an accused victim of a sexual crime. And this is a very serious question, and there's a lot of attention right now to issues of violence on campus, particularly sexual violence and violence against women. And how do you balance the respect for the dignity of those who are making these claims, and in many cases coming forward with allegations despite significant fear of retaliation, significant recriminations by the public? How do you balance, those very important sensitivities against the due process rights of the accused? And that brings us to this case out of the University of Cincinnati. So we have two students that are referred to as John Doe and Jane Roe. And what the court agrees on is that John and Jane engaged in sex at John's apartment. Now, John says the sex was consensual, and Jane says that it's not. There's just no physical evidence that supports either student's version, the court says. So what do you do in a situation like that? And particularly, what does the university do? Well, in this case, when Joe raised her claim of against John Doe with the university held a disciplinary hearing. And Jane Roe didn't appear at the hearing, and the university found that John Doe was, quote, responsible for sexually assaulting Roe based on her previous statements to investigators. So the University of Cincinnati suspended John Doe for 2 years, which was later reduced to 1 year. And the legal issue here is, was that hearing unfair? As I mentioned, Jane didn't appear at the hearing, and there might be very good reasons why Jane would not have wanted to appear at the hearing. But was it unfair? Did it violate due process because he didn't have a chance to confront his accuser, which is something that we would expect in a criminal trial?
Rob, does Sheldon mean confront the accuser directly?
Well, that's an interesting aspect of this case. So the short answer is no. What the accused student is saying is, well, I have the right to submit questions to the panel that's going to decide this case, who then will turn around and ask the questions of the accuser. And this is actually a procedure that itself has been subject to constitutional challenge in some other courts. Interestingly, it's a procedure that was recommended by the Dear Colleague letter, somewhat infamous Dear Colleague letter that was sent by the Obama administration to universities all across the country, sort of suggesting procedures to be followed in these types of cases. And that Dear Colleague letter has itself been challenged, as not legally challenged, but sort of challenged in the public as inconsistent with principles of due process, and actually was recently withdrawn by the Trump administration. So, interesting sort of aspect of this case is what the plaintiff here is asking for is not to throw out the Dear Colleague letter. He's just saying, I just want the minimum amount of due process that was suggested by the Dear Colleague letter.
And that's the basis for the Sixth Circuit's decision. Fundamentally, the Sixth Circuit says, look, the Due Process Clause guarantees that state university students who are facing some sort of long-term exclusion, some sort of serious penalty or consequence as a result of an investigation, that they have due process rights, just like in any other situation where the state is potentially infringing on the life, liberty, or property of an individual, right? And the court said that this credibility determination that the university engaged in when it was making the decision whether or not to suspend John Doe was fundamentally unfair, because there really wasn't any opportunity that you would expect in the normal due process context to again, we're using the term confront, but to confront the witness, to have an opportunity to test the witnesses or the accuser's claims and figure out whether or not those claims ought to be credible.
Sort of a lurking issue here, which is, is it really appropriate for these kinds of issues to be worked out at all in the campus disciplinary system. I mean, this is an allegation of a serious crime. And why is this being dealt with by a campus disciplinary board and not by police, prosecutors, and the courts? And that's sort of maybe a theme running through a lot of these cases, which is the legalization of what is happening on campus and issues being dealt with through sort of campus procedures or the courts in ways that, legalize them in ways that may be not what we're used to seeing, and it's sort of changing the structure of the campus through the courts.
Right. I think, going back to the Dear Colleague letter that Rob mentioned. So in 2011, what that means is the Department of Education issued this letter, purportedly a guidance letter, saying, look, we're reinterpreting Title IX, and Title IX says that no person in the U.S. shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So the Department of Education said we're reinterpreting Title IX to give the federal government, the Department of Education, authority to dictate, exactly the types of procedures colleges should use when there are these sexual assault allegations, right? And so it had a pretty profound effect on the administration of colleges across the country. And all of a sudden, you have the Department of Education basically assigning, university bureaucrats who don't have any sort of training in criminal procedure or anything else, and you're assigning these university bureaucrats as judge, jury, executioner, all in one, and you're really streamlining the process for handling these types of allegations. One of the biggest criticisms of the Dear Colleague letter is that it purports to require universities to apply a preponderance of the evidence standard when making determinations about these sexual allegations, right? And that matters because in a criminal proceeding, if in this case Jane Roe were in a court and she were accusing John Doe of a crime, and if it were a criminal trial, then the standard would be, a jury would have to decide that it's beyond a reasonable doubt that John committed the crime, right? A preponderance of evidence basically means more than 50% right. So it's a little bit more than a coin toss likely that John, assaulted Jane. And that's a much lower standard for depriving somebody of life, liberty, and property. Or in this case, really fundamentally, altering, their ability to pursue an education. They might get kicked out of schools. They might get banned from state university permanently.
And this is something you have to disclose to future employers, to future what have you. It's sort of on your quote unquote permanent record. Right.
And so it raised a lot of public criticism from a lot of different corners, particularly among criminal defense lawyers who said this just doesn't make sense. We can't change all the rules because it happens to be happening on campus.
Okay, that concludes the show. Thanks for listening, and be sure to tune in next time for more judicial engagement. This is John Ross from the Institute for Justice, expecting that you will be engaged.